Hi, my name is Megone Trewick, lead estate planning and probate attorney here at the law office of Bryan Fagan. Today, I want to talk about whether or not you have to probate a will. You're the only beneficiary. Do you still have to probate that will? First of all, my deepest condolences, because if you're watching this video, you have a loved one who passed away. And therefore, I want to let you know that I'm approaching this topic very carefully and very measuredly, knowing that you have experienced that loss. In the midst of this, however, you now have an estate that you have to take care of. This decision whether to probate becomes very important because even though your loved one passes away, the bills do not stop, the taxes do not stop accumulating, and therefore there is a necessity to probate the estate. As a sole heir, you may be considering, my mom left everything to me anyway. Why do I have to pay thousands of dollars to a probate attorney to tell me what this will already said? Unfortunately, along with the assets usually come debts. And because of that, you have to probate the estate because you cannot take care of those issues outside the court because you are not the actual owner of the property until that has been bestowed on you. First of all, if you have a will that you need to probate, you need to get yourself an attorney. Why can't you be a pro se applicant? Why can't you just file your own application? That's because you have creditors. You as the beneficiary cannot reasonably be expected to represent and to properly administrate an estate for the benefit of a creditor without feeling that you are unjustly being enriched. You may not be treating those creditors fairly. Because of that, Texas Estates Code requires that you get an attorney to file this application to walk you through the process of administrating this estate. If that's the case, the attorney will step up, do the application. You then have to take the will, the original will, to the courthouse. Note that you will not receive that will back. Therefore, if you want a copy, you want to make the copy because the court is not giving you that will back. That will is now in the custody of the state of Texas and it will no longer be yours. The will gets given to the court. You then notify the creditors. You then serve all the people who are named as beneficiary under the will, or they'll provide you waivers. In your case, you're the applicant, you're the only beneficiary, there is no need to serve you. However, you need to do your notice to the creditors, you need to publish that, you need to get your affidavit provided to the court as proof that you have done so. Then you set your hearing date, you show up, the court admits the will into probate, gives you letters testamentary, and then you get to then administrate the estate. You have to pay the creditors, then take care of all the expenses of the estate. Then, and only then, can you distribute the net amount to yourself. You have to also let the court know through an inventory and appraisal all the assets of the estate and your approximate value of it. That really is a summation, brief summation of what it actually takes to probate a will. But if you want to learn more, please visit us at www.bryanfagan.com/probate guardianship, or you can visit us on YouTube, Facebook. Please like us, please follow us, or you can just give us a call, 281-810-9760. Thank you.